Record. Should be recording now. Yeah. Hold on. Yeah, okay. Feudal society. Let's go back in time as to what a feudal society was. Now, this is information you had never heard before. All right. And if you know about the feudal law, then you are some sort of a history scholar. And I need to be sitting in a classroom learning from you, because this is something I never even heard of before. All these people who taught law and talked about the courtroom over time, from Howard Freeman, is one of the first guys I started learning from. And Howard Freeman, he wrote these old books called, one of them's a famous book, I think it's the UCC Connection. They all talked about how, which seems like a logical conclusion, that we're under these admiralty law, maritime law, commercial law, all these different law forms, and we're not following the common law anymore. We're not following the equity anymore, like it says in the Constitution. And the courtrooms operates under these different types of jurisdictions. And it all kind of made sense. And that may be so. Okay, but let's go back and actually uncover the root of what actually is going on, because those are conclusions that really don't have a lot of foundation and support. But I will show you, according to the law, what it says as to what actually happened with this 14th Amendment. And if you're going to notice some images here that look familiar. You see that pyramid there? It probably looks familiar. This pyramid is on a lot of our, a lot of things in the U.S. right now. And on the very top, you got the king, you got the peasants, the military aid, the lords, the knights, and on the bottom is the peasants. So you got the king, the fief, right, and the military aid going up, and then the protection coming down from the king and the military to the peasants, and the peasants going up to pay the rent, farm the land, owing allegiance, owing military service, and owing their fealty to the king. In return, the lords and nobles agreed to supply the king with soldiers and horses for his army. In return for these knights, they fought nobles of the king. Peasants worked the land, and the nobles and knights, who in turn offered them protection from the other lords. So can we also agree here that this phoenix sign is everywhere? Bald eagle, phoenix sign is pretty much anywhere, any courtroom you go, and you'll see these images. Okay. These are images from the feudal law. Just do a Google search. You'll find the last images about the pyramid, and then this image about the phoenix are from the feudal law. What are they doing in our United States system? Well, because we're under feudal law. That's exactly why. So let me go ahead and break this down a little further here. All right. So for those who are just absolute scholars and they're just not convinced, they're super skeptics, I'm with you. I'm that same way. So I'm with you 100%. And if that is you, find this document called Historical Jurisprudence. It's a 540 page treatise, and it's from Johns Hopkins University. And it's going to take you through the background of the law system. 1911, New York, Macmillan Company. You can find it online. Historical Jurisprudence, search that PDF, and then put the word PDF at the end. So it's too long to go through right now. But if you go through this document, if you are a scholar, I'm just giving a reference point, you'll notice that over time, through the law system, starting in Babylon, and all the law systems that they've documented over the last 5,000 years, because we only have, I think it's 5,000 or 6,000 years of written history from scholars. What happened before that, we don't have any written history of. We don't know. So we can only go back to about 5,000 or 6,000 years in Babylon and before, and times before that we're really going through this law system and where it all comes from. So, and in that, they all operated under this feudal system, where the slavery was just rampant. Every society had slaves, and that's just either they were voluntary or they were involuntary. And involuntary and voluntary servitude was very common. That was the feudal system. So not only in Asia, but also in English law, and then Babylonian law, and then going on even to German and other European laws, all the way carrying over to now into the new 14th Amendment. I'm going to show you why. If you first, let's go to after the 14th Amendment was passed, there's a case here called the Slaughterhouse Decisions. Slaughterhouse case is 1872. Now, in this case here, let me just, it's a long, very long decision, but I'm going to give you a summary here and stop the share. So basically, you could read that case, and I would recommend it because it's foundational. And what happened was these guys came from Louisiana Territory and Louisiana State, New Orleans area, and they were slaughtering animals and causing a lot of debris into the Mississippi River. And the dead animals were being thrown in the river. So the state got involved and they said, well, we need to pass a law that makes it illegal to dump all your feces from the cow into the Mississippi River, and also make everybody only go to the one slaughterhouse for the state. So you can no longer slaughter your animal. And it was on the grounds of protection. We're going to protect you, keep you safe, because these bad slaughterhouses are making your river dirty. And I mean, people voted for it because the river was dirty, so it passed. All these butchers came together and they appealed to the Supreme Court. Now, this is freshly after the 14th Amendment, 1872. In this case, the Supreme Court was, I'm reading the case, I'm thinking, oh, they're definitely going to overturn this decision. This is an unconstitutional law. No. You know what they said? The states, these white slaughterhouse butchers, they had no right to sue under the 14th Amendment because they're not former black slaves, under this feudal law. I mean, I didn't say that exactly, okay, but they're not they're state citizens. They're nationals. They have no right to sue under the 14th Amendment for protection. So the case went back. They said, you need to go to the state. You need to handle this at the state level. You have no right to sue under this. That raised a big question right there. Now, shortly thereafter, a case called Downs v. Bidwell in 1901. This is actually after the Wong Kim Ark case came out. Well, even before I go to Downs v. Bidwell, let me pause that for a moment. Pause. Okay. Before we go to Downs v. Bidwell, there's a case called Plessy versus Ferguson. Plessy was a black. Now, this is about the Jim Crow laws. All right. He was 1/8 black. And like a very progressive newspaper, they funded him in a case to try to overturn these Jim Crow laws, which, had people in the back, black people in the back of the train, and then white people in the front at this time in Louisiana, in the South. So Plessy gets on the train and he boards the train where the white guys sit, and he was 1/8 black, almost where you couldn't even tell he was black. However, the conductor stopped the train, threw him off, and they arrested him, threw him in jail. Plessy appealed to the Supreme Court, and since then the case has been overturned. I mean, we know this law is, they don't do this anymore. We have people in separate bathrooms, but at the time, this was the law, and they said, oh no, it's okay to have Plessy, a 1/8 black guy, in the back of the bus because he gets equal treatment as the white guy. They called it separate but equal. And this separate but equal doctrine, okay, the conclusion is it's relevant to citizenship. Not only, at the time of the case, Plessy versus Ferguson, but the citizenship doctrine of there's two political statuses, equal. U.S. citizen, U.S. national. Or at the time of the 14th Amendment, they called it state citizen. They've changed these wordings around, but they call it separate but equal. Separate but equal doctrine comes from Plessy versus Ferguson. Now, there's another case called Downs v. Bidwell. In Downs v. Bidwell, there's a dissenting opinion by this brilliant jurist that was one of the most famous of all time. And he's actually let's see if I could share this. This guy is like a historical legend in scholar and jury scholars because he's called the Great Dissenter. And I should always remember his name, but for whatever reason, I'm drawing a blank. I'm gonna have to pull it up here. So I'm going down through this case. It's a 79-page opinion. So for all you guys who are scholars and you love to read legalese, you're going to enjoy really getting into this case. But let me go down to the parts here. I think I should have it highlighted. Here he is, Justice Harlan in the dissent. He's what's called the Great Dissenter. I concur in the dissenting opinion of the Chief Justice, all right, of Mr. Justice Brewer, and he goes through these unconstitutional acts of Puerto Rico, and he's talking about Downs v. Bidwell was a case going through national government, talking about the rights of the national government after the 14th Amendment, and the idea prevails with some. Indeed, it found expression in arguments at the bar that we have in this country substantially or practically two national governments. One to be maintained under the Constitution with all its restrictions, and the other to be maintained by Congress outside and independently of that instrument by exercising such powers as other nations on earth are accustomed to exercise. All right, so the dissenting opinion here is making the argument that wise men who framed the Constitution were patriotic people and unwilling to depend on for their safety upon it. In the opinion referred to as describing certain principles of natural justice inherent in Anglo-Saxon character, which need no expression in constitutions or statutes to give them effect or secure dependencies against legislation manifesting hostile in their real interest, stating that this other form of government here, okay, these guys, the separate side, he's saying here, there's two forms of national government. These guys on the constitutional side, they didn't need all of this administrative legislation. It didn't apply to them. You see that? He's stating that they're separate from that. The wise men who framed the Constitution and the people who adopted it were unwilling to depend on their safety upon that. And the opinion referred to describe the certain principles of natural justice inherent in Anglo-Saxon character would need no expression in Constitution or statutes to give them effect or secure dependencies against legislation manifestly hostile to their real interests. No higher duty rests upon this court than to exert its full authority to prevent all violation of the principles of the Constitution. So the dissenting opinion here is stating that this is what happened in this case. He's, of course, dissenting, saying that he disagrees with it, but we have to live with it. There's two national forms of government, one under the Constitution, okay, the old common law to be maintained with all its restrictions under the Constitution. And then the other side, which they call the administrative state or the deep state, or the parts that are all under Washington, D.C. Now, tying that back to citizenship, we got what? Two forms of citizenship. You're either free or you're a slave. Okay? So before we go on to the next, probably stop the recording here and before we go over to the Wong Kim Ark case to really back this thing up, this video is going to get long if we go into that. So let's just pause the recording right there, and we'll go into the Wong Kim Ark decision and some of the FAM guides, and then we'll go into like a real practical thing on what we can do about it. All right, Thomas, we good with that? Stop recording.
Excellent.